Welcome, Divisional Accounts Officers and PIPFA candidates, to today's explainer. We are going to be breaking down the strict, step-by-step statutory blueprint of the Land Acquisition Act of 1894. Honestly, whether you're out there in the field managing massive state projects or gearing up for your compliance exams, getting a solid grip on the exact chronological flow of this legislation is absolutely vital. So, let's get right into it.
Okay, think of this whole process as a highly structured framework. It's essentially a balancing act between immense state power on one side and uncompromising statutory accountability on the other. When the government decides it needs private land for public use, it's never just drawing arbitrary lines on a map. No way. It triggers this incredibly regulated sequence of financial and legal obligations. And here's the kicker: you are the ones directly responsible for monitoring all of it.
There's a concept I really want to emphasize here, and it's basically the core thesis for our entire explainer. Mastering the Land Acquisition Act requires understanding the delicate equilibrium between decisive state authority, the protection of citizen rights, and strict financial compliance. Every single move you make during land acquisition is a high-stakes test. A misstep doesn't just mean a slight project delay. We're talking immediate audit failures, messy legal injunctions, and massive financial leakages for the state.
Right. So here is our statutory roadmap for today. We'll kick things off with initiating land acquisition, then move into objections and declarations. After that, we'll cover formulating the award, followed by valuation and urgency procedures, and wrap up with execution and audit compliance. This flows exactly how you'll encounter it in the real world.
Step 1. Initiating land acquisition. This is where state power is officially unlocked.
Everything begins with Section 4. Think of this as the official starting gun. It legally authorizes the state to actually step in and breach private property rights for surveying purposes. The initial legal notice gets published on the official gazette, and then that translates into 4 physical actions on the ground. First, entering and surveying for topographical mapping. Second, subsoil access to figure out geological adaptability. Third, physically demarcating the boundaries. And finally, clearance, which means clearing out things like crops or fences.
But hold on, because here is a massive audit red flag you need to watch out for. You absolutely must give exactly 7 days prior written notice before entering any enclosed dwelling. Plus, there's a strict financial obligation attached. You have to make a mandatory tender of payment for any necessary damage caused during that survey, like, say, accidentally cutting down a farmer's standing crops. If you overlook this, well, you've essentially failed the compliance test at Step 1.
Moving on to Part 2, Objections and Declarations. This is where we see that balancing act between citizen rights and state authority really play out. So, how exactly does the law balance a citizen's right to due process against the state's authority? It works like this. Under Section 5A, citizens are given a strict 30-day window from the notification issue date to submit any written objections to the collector. The collector hears them out and recommends a decision. But once the commissioner is satisfied and actually makes a decision, boom, we trigger Section 6. The Section 6 declaration gets published, and it serves as conclusive evidence that the land is needed. This acts as an absolute override of any prior notifications. At this point, the state's intent is totally locked in.
Part 3. Formulating the collector's award. The declaration is out there, so now we shift gears from legal theory into hard, concrete numbers.
Under Sections 8 and 9, the declaration gets translated into actual physical measurements and formal notices. First up, the collector takes the formal order. Second, the land is physically marked out on the ground. Third, precise measurements are taken and a master plan is generated. And fourth, and please pay attention to this one because it's incredibly important, you have to serve a minimum 15-day notice to all interested persons. We're talking occupiers, co-proprietors, mortgagees. They're required to come forward and state their exact compensation claims.
Now, all of this is happening against a literal ticking clock. Section 11B mandates a totally rigid 6-month statutory limit. The entire acquisition process must be completed within 6 months from the date of the initial Section 4 notification. It's a completely unforgiving timeline.
And what happens if you breach that 6-month countdown? The consequences are honestly severe. If you miss the deadline and your reasons are deemed unsatisfactory, the collector is legally obligated to formally explain the delay right there within the award itself. And it gets worse. The collector faces personal responsibility and the potential initiation of disciplinary proceedings. So as an accounts officer, keeping a hawkeye on this deadline is absolutely a top priority. All right, assuming we actually beat the clock, we arrive at the Section 11 Collector's Award.
This is the final, conclusive legal dossier, and it's built on three main pillars. First is the true area, which is based on those exact physical footprints we talked about. Second is total compensation, meaning the definitive monetary value of the land. And third is apportionment, which is the legal division of those funds.
That brings us to Part 4, Valuation, Compensation, and Urgency. Let's dig a little deeper into that middle pillar, the money.
You can't just throw out a random number for financial valuation. Under Section 23, the law demands a highly strict mathematical formula. Total final compensation equals the precise market value, calculated strictly as the Section 4 notification date. To that, you add specific damage variables. This could be standing crops, severance damages, or relocation expenses. And then finally, you tack on a mandatory 15% statutory surcharge. This surcharge is added specifically to account for the compulsory nature of the state taking the land. They don't have a choice, hence the extra 15%.
Once you have that total final compensation figure locked in, it has to be legally apportioned, basically slicing up the pie. It gets divided among all known interested persons based on their respective ownership and tenant rights. So the funds might be split up between primary proprietors, long-term tenants, and any mortgagees who happen to hold liens against the property.
But let's pause for a second and think about a real-world field scenario. What happens if the state simply cannot wait for this standard, multi-month process to play out? Say there's a sudden emergency, like an unforeseen river shift that's threatening a town, or an incredibly urgent railway need that demands immediate land possession. What then?
That is exactly where the Section 17 urgency bypass comes into play. The urgency route allows the commissioner to direct that Section 5A objections won't apply at all, you just skip them. So instead of waiting for the final award to take possession, the state can take absolute possession just 15 days after the Section 9 notice is served. However, there is a massive catch. Estimated costs must be deposited up front before taking possession. You have to show the money first.
And finally, Part 5, Execution and Audit Compliance. This is the most critical phase for all of you future accounts officers, the strict financial execution and the very real penalties for getting it wrong.
Even after the award is totally finalized, landowners can still dispute the measurement or the compensation amount under Section 18. This gives them the right to demand that the collector refer the matter to the court. But they have to follow strict deadlines. They have exactly 6 weeks from the date of the award if they were actually present at the hearing. If they weren't present, they get 6 weeks from receiving formal notice or up to 6 months from the award date, whichever expires first.
From a strict audit perspective, your compliance duties go well beyond just watching timelines. The Secretariat instructions dictate that you absolutely must consult district revenue officers for land cost estimates prior to sanctioning any project. On top of that, intergovernmental transfers of land have to be booked at market value. Oh, and remember, the raw cost of land acquired for the Public Works Department is debitable directly to PWD accounts.
Now, why does this level of exactness actually matter? Well, consider some real-world findings from the 2023-24 audit report. One major case highlighted military land that was illegally leased out for commercial projects without central sanction. Another case revealed massive revenue leakage simply because they failed to deposit the mandatory 25% government share of commercial rent. Bypassing proper cost allocation rules isn't just a paperwork error, it directly leads to colossal financial disasters like these.
And we definitely can't forget about the Section 34 penalty. Under Section 31, you're required to tender payment to interested persons before taking possession. If you fail to pay, or if you fail to deposit the exact compensation amount in the court for a disputed title before taking the land, Section 34 hits you with a mandatory 6% simple interest penalty per annum on the awarded amount. That is a direct, completely avoidable hit to the state's treasury, and you better believe auditors will penalize you for it.
We have covered a tremendous amount of ground today, from the very first Section 4 preliminary notice all the way to the rigid 6-month deadline of Section 11B and that stinging 6% penalty under Section 34. So, I want to leave you with this final thought. When you are sitting there as the final checkpoint between state power and citizen rights, are you truly prepared to enforce these rigid statutory deadlines and safeguard the public treasury from catastrophic audit failures? Keep this blueprint in the back of your mind, study these sections closely, and I'll see you in the next explainer.